Okay. Thank you so much. I'm Erin Kilbride, as Liam said. I'm from Frontline Defenders. Thank you, first of all, for that first phenomenal panel. I think it was a really, really great introduction. And so we are going to continue today by talking to some people who struggle for the realization of those rights, of which we were speaking this morning. And I think one of the things that's going to come through quite clearly is that in their struggle for the recognition of the rights of pregnant people, women, girls in their communities, they have their own rights violated for doing so. Many reproductive rights defenders around the world are threatened, harassed, intimidated, sometimes imprisoned, or even physically attacked for the work that they do. We are lucky enough, and I am honored, to moderate a discussion of 3 such women today who have inexplicably decided to continue in their struggles despite these risks. Lucia, who is currently being mic'd up right now, is a feminist lawyer from the Argentine Center for Legal and Social Studies. She has a master's in human rights, and in addition to extensive work for women's rights and reproductive justice, she has also provided legal aid to families of disappeared persons under Argentina's last military dictatorship. Sneha is a legal advocate with the Supreme Court of India alongside her work with the Human Rights Legal Network. She has advocated for changes to the Medical Termination of Pregnancy Act to ensure that choice and bodily integrity are respected. She has also worked for the prevention and prohibition of child marriage and to better ensure that contraceptive services and information are available at the local community level. Seham, who is also assisted by our translator Hanan, is an Egyptian feminist and also an indigenous people's rights defender. She's from the Nubian community in southern Egypt in Aswan. And in addition to being one of the leading voices trying to reclaim her community's land, in her free time, she founded the region's first organized feminist movement in recognition and to fight back against what she called a normalization of gender violence in that region. And I think one of the really interesting things that will come through on our panel today are kind of the distinctions between what the fight for reproductive justice looks like in urban centers and in rural centers, and how services can be extended to those outside of them. So one of the things, just before we started, that Sneha and I were speaking about is how the legal struggle is just one small facet of the fight for reproductive justice in her context, and indeed in others, in the conversations that I've had with Seham, and I'm sure that we'll have with Lucia today too. And this phrase, which also came up earlier, this pro-life phrase, I've now heard over the course of the morning, in I think 4 different languages so far, that there's some version of that phrase that exists in so many societies, even ones in which, as Sneha was explaining, in India, where you have legislation that in many parts of the world would be considered incredibly robust in terms of the term and the time frame in which a woman is able to access an abortion or termination of pregnancy. And yet still, there are societal restrictions. There are terms like pro-life that prohibit women from accessing these things. And it just got me thinking in the past few minutes. I'm from the US, if you can't tell. I don't have a particularly Dublin accent. It got me thinking, what does the term pro-life mean, for example, in a place like Texas in the US, where abortion clinics are shut down and legislation is introduced to force women to listen to the heartbeat of a fetus before she's allowed to access an abortion. But in the same state, a man in full combat gear can walk into a church, murder 26 people, one of whom is a woman who is 8 months pregnant. And to that we look at and say, sure, there's nothing we can do about that. I'm not saying US gun laws are the norm, but that there's this dichotomy that exists within the framework of pro-life discourses that can be really restrictive to activists working on these issues, right? How do we understand pro-life in the Irish context, where women cannot access life-saving services, but we continue to uncover mass graves of children? How do we understand it in the Egyptian context, where women cannot access the services that they need, but Seham's community 50 years ago was pushed off their land in a process that resulted in the deaths of indigenous children? So what does it mean to have this pro-life discourse that moralizes women who seek reproductive services and indeed endangers the activists who are struggling for justice for them? So I am more than honored to ask each one of our activists here today to give a short 10-minute presentation about the context in which they work and the work that they do, and then to open it up so that we can all ask questions to learn from their brilliance and from their experience and indeed from their successes, because the picture is grim. I definitely will not deny that. But there also have been successes in each of these contexts that each of these women have won that I think are also really worth examining and seeing if those of us who are working for these things in our own communities can't learn from them. So would you like to start?
Good morning, everyone. My name is Sneha Mukerjee. I'm an advocate with Human Rights Law Network in India. So now, we had a discussion over the past 2 days, I think, and when I see the law in India, it looks like pretty moderately liberal to me. But then when we see the struggle we have in India, it's really different. Because what we are struggling with is to have a more open-ended law, but with its own sets of qualifications. But at the same time, we are also struggling to have access to services. Because very recently, the World Health Organization came up with a fact report that said, on unsafe abortion, that said that countries with safe abortion laws, access to liberal abortion laws, have a risk of about 13% of unsafe abortion. As compared to countries with no abortion laws or restrictive abortion laws that have about a risk of 75%. Now, India, with very, very moderate or liberal, for that sense, liberal abortion laws, stands at a risk of about 60% unsafe abortions. Now, the reason being, no access to abortion services, no access or information about contraceptive, and also the moral question that we all almost struggle with. Now, first, I think we would start with what is the legal regime in terms of abortion in India. If we look at the Medical Termination of Pregnancy Act, which was legislated in 1971, it says that up till the first 12 weeks, a woman can request for an abortion for whatever grounds. From 12 weeks to 20 weeks, she can request for an abortion. She can request and not demand for an abortion in case of two circumstances. First, being if the continuation of the pregnancy is causing any kind of physical or mental harm to her well-being, or second, if the child were to be born, the child will be born with such physical or mental handicap that it would cause serious damage to the condition of life of the child post-birth. Now, we have to look at this fact that there is no question of viability. The law does not address the question of viability. It addresses the standard of life the child would have post-birth if the child is born alive. And then we have an exception to the law that says that if there is a serious risk to the life of the mother, then an abortion can be done at any stage during the pregnancy. Now, the problems that we face in India. First, when we say risk to the life of the mother, it means a life and death situation, where it is certain that continuation of the pregnancy would certainly cause death. But when we go back to the research committee report of 1967 that resulted in the legislation of 1971, it does very, very expressly talk about right to physical and mental health and well-being of a woman when we talk about right to life. But somehow it does not reflect into the law or the interpretation of it today. So when the whole abortion debate has been pretty recent in India, the first time we went up to the court was back in 2008, when a gynecologist from Bombay, which is one of the major cities in India, approached us and said that one of her patients suffered from a miscarriage. What really happened was that at the 22nd week, she found out that the fetus had a severe fetal abnormality, wherein the heart of the fetus was not functioning, and that made the fetus incompatible with life. And she did not want to continue the pregnancy. So they went to the Bombay High Court and requested for termination of pregnancy. The court said that the law does not allow it, and we do not think that we can hear you on merits in a case like this, and therefore we cannot allow it. Eventually, she miscarried, went into depression, and had to go through and a very long term of medication just to come out of the whole trauma that she had been through. That is when the first time somebody came and approached the Supreme Court challenging the constitutionality of the Act. Constitutionality in the sense that the first provision that gives a woman the right to request to two medical practitioners to assess her and the condition of the pregnancy and see. And if both the medical practitioners think that the pregnancy is causing the continuation of the pregnancy is causing some kind of harm, physical or mental, to the mother, or if the pregnancy is continued and the child is to be born alive, then there would be severe physical and mental injury or harm to the child, as a result of which the child will have a very, very poor standard of life, then a pregnancy can be terminated. But the problem is, this law was legislated some 50 years ago. And if we look at the medical advancements, it is very, very safe to do an abortion at any stage in time. So when we've approached the court said, at this stage, we don't think we are ready to first go into the merits of the case because it is a very, very technical issue. And the court automatically asked the government of India to give its comments. Now, it's been quite a while, and the government has still not really given its comments in writing. In the meanwhile, what really happened was a new committee was formed with the Chief Secretary of Ministry of Health, and they came up with an amendment bill that sought to increase the limit from 20 weeks to 24 weeks. And apart from that, create an absolute exception for cases where a severe fetal abnormality has been detected in the pregnancy. And this exception would give the right to women to request for an abortion at any stage of the pregnancy, and only on the opinion of one medical practitioner, as compared to that in the present Act, which says two medical practitioners. But this amendment bill is still pending before the Parliament for approval. We almost saw the approval go through, but then earlier this year, there was a racket that was found out in a certain part of India, wherein a homeopathic doctor who was not a registered medical practitioner was running sort of a small unregistered nursing home where he was constantly continuing to do sex-selective procedures. And in the process, a woman lost her life. And India, and given the social demographics in India, sex-selective procedures is a very, very big issue. We do have a law that restricts it, but it's not really something that's working out for us. And that is an issue that has restricted us from having any change or any legal reform in the abortion law, because the amendment bill not just sees an extension in the existing law, but it also looks at elaborating and widening the definition of a medical practitioner, a registered medical practitioner. At this point, it is only gynecologists and registered MBBS practitioners, but it does look at extending it to homeopaths and Ayush workers who are also doctors in rural parts of India. Now, the recent uprising that has happened in India has been really recent. I think last year, in July 2016, we went up to the Supreme Court with the case of an 18-year-old girl who had been raped, and she was about 24 weeks pregnant. At the 23rd week, she found out that the fetus had a severe fatal fetal abnormality, which made the fetus incompatible with life. And that is when we again went up to the Supreme Court and challenged the constitutionality of the Act and told the court the continuation of this pregnancy would cause it would qualify in both the categories. First, the fetus is not compatible with life because the skull in the fetus was not formed, because of which the fetus would not survive childbirth at all. And apart from that, the pregnancy was the cause of rape first, and the fetus would not survive, meaning that both of these factors would severely affect her physical and mental health. So for the first time, I understand, the Supreme Court agreed to hear us and created and established a medical board of senior gynecologists, psychiatrists, and general physicians who would assess this woman and decide whether it was okay to go for an abortion. And after a 2-day assessment, the medical board gave an opinion that she is 18 and the fetus is not compatible with life. The risk involved in doing the abortion at this stage is exactly the same as doing it at full term. And at this stage, continuation of the pregnancy would only cause more and more physical and mental trauma to her, and therefore a termination should be allowed. That was the first case where we thought that we did see some change in the law and some change in the idea that the judges in the apex court had. But we had still not gotten to the main part of the whole argument. Because the first few cases that we did this year were also cases where the fetuses were incompatible with life, which means it was an easy choice. Because in India, what we often face is not really a legal argument, but a moral argument. Something that I think Francis and you both of our last speakers addressed. The argument and the choice between an existing life and a potential life. And that is, in India, often a moral question. So when we got the first few orders in where the court allowed termination at 24 weeks and then 26 weeks, we thought that somehow we had put across the argument, the word, the idea that we were trying to advocate. And then came a case where this woman, she found out at the 26th week that the fetus had Arnold-Chiari syndrome. Now, Arnold-Chiari syndrome is an abnormality where the fetus would suffer severely with physical and mental damage, but would possibly survive childbirth. It would be alive for a variable period of time, but with a very, very poor standard of life, given the physical and the mental condition. We went to the court, hoping that the court would go to the medical board, and the medical board would give us an opinion that would be sensible and would also look upon the condition of the fetus, because the law says so. The law does not talk about the viability. The law talks about the condition and standard of life of the fetus. However, the medical board said that we accept the fact that this child will have a very, very poor standard of life, would always be dependent on medical help, and would always require a person to assist him or her in whatever condition and whatever life. Also, we do not know how long will the child survive. It may be 2 days, it may be 2 months or 20 years. But because it has survived until 27 weeks of pregnancy, there is a 60 to 70% chance that it would survive childbirth. And therefore, we cannot give an opinion in favor of termination. And when we tried to argue the case on merits before the Supreme Court, the court said, we don't think you are in a position to argue it on merits, or we are in a position to hear it on merits. Brought us back to 2008 again. This woman, she went back to the same hospital that gave an opinion against her abortion, gave birth to a baby boy. The hospital tried its best to do whatever it could for 7 days, when the child was kept in an NICU to be treated by a neurosurgeon to see if something could be done to save the child. They could not. Eventually, after 7 days, they gave the child to the mother and said, do whatever you can do and treat the child well as long as the child is alive. The child died after 2 months. And I have been in touch with her, and she's still in therapy. It's been quite a while, and she's still in therapy, and she refuses to speak to anybody at all. This case was an eye-opener, not just for us, but also for the courts, I think, because eventually we went up to the court with multiple such cases, and seeing what happened to this one individual and seeing how a decision like this affects an individual, the courts and the medical boards have opened up to the whole issue from a very, very legal and medical perspective. And very recently, we've been able to get orders for abortion up to the 31st week, which I think is quite an advancement for us, because somehow the questions that the court now asks is not if the fetus is viable or not, but if there is a severe problem or if there is a severe abnormality with the fetus, is there a way of treating that? Is there a way of saving the child from having a poor standard of life? Because the argument that we most often get from the government and the doctors who represent the government is, irrespective of what is the condition of the fetus, we should give the fetus a chance. And I have never seen them argue or even touch upon the aspect of the health or the effect the pregnancy or continuation of this pregnancy would have on the mother, which it feels like is a very, very pro-life kind of an ideology. And eventually there are medical opinions that come from the doctors that are very neutral in nature, which leaves it to the courts to decide. And we have seen cases where the courts have been reluctant to give an abortion order because the court thinks that the medical board is neutral, so if there is no additional risk, if there is no additional physical risk to the mother, then it is okay for the mother to continue the pregnancy. And in those cases, we've had to ask the court, is it okay to, in a given situation where we know as a fact that there is no medical assistance that can be provided to this child post-birth that would change the condition of the child, and we know as a fact that these children would suffer from severe abnormalities and would have a very, very short lifespan, should we not consider the condition and the position in which this continuation would put the mother in? And we have been lucky, and the courts have been very receptive, and we've only got positive orders in the past few months. Very recently, we got a very good order for a 13-year-old girl who was raped multiple times and became pregnant, and the parents found out at the 27th week that she was pregnant. They went to a doctor, and automatically the doctor reported to the police, because we have a specific law that says in cases of child sexual abuse, anybody who has information of it is automatically obligated to inform the police and report it through an FIR, and if not so, they would be criminally prosecuted. And this doctor automatically contacted us because she was not 13 actually, she was 12 and a half. She was 27 weeks pregnant and really, really weak. And no gynecologist wanted to touch upon the case because they know that if they did it, they would be prosecuted criminally. Now, we have an exception under the law, both under the POCSO rules, which says that in cases of minor rape victims, the doctors who are assessing the child would have to give immediate medical services, which also include termination of pregnancy or contraceptive in cases of a possibility of a pregnancy. However, it is also restricted by an already existing law on termination of pregnancy that says that you cannot do it beyond 20 weeks. So the argument then was that it was a normal pregnancy. The problem was the pregnancy itself and nothing within the pregnancy that was causing the harm. We went up to the court, but by that time she was already in the 30th week. And the argument that came from the government was, I mean, so what, she's 12 years old. I mean, she's already completed 31 weeks. Let her go for 6 more weeks and she'll give birth to a child. This was the argument that came from a doctor who was standing for the government of India. And at that point, people who argue for the moral choice, we stood up and just said, is it morally correct to ask a 12-year-old girl to actually continue her pregnancy and give birth? There is a proper legal argument to it, but even with people who have been arguing morally on the ground that everybody should have, a chance, how is it morally correct to ask a 13-year-old girl to continue her pregnancy and give birth to a child? And how can we even imagine the effect of it that would be caused to her? And the court automatically asked the medical board to immediately go through with the termination of the pregnancy, irrespective of whatever opinion the government would have. Now, this is something that we have been able to achieve in about a year's time. The courts are now more open about the argument that abortion is one of the most safest procedures that are possible if done in safe conditions, which somehow brings us to the argument that the issue in India that safe abortion service is something that is not readily available. And along with, I think, liberalizing the abortion regime in India, the courts are also looking at creating a stronger medical framework and infrastructure for women, especially in rural areas of India, to access abortion, and even quickly so. But apart from that, what we're really focusing on right now is getting strict guidelines, specific guidelines from the Supreme Court, so that every individual would not have to go back to the Supreme Court and get an order for themselves, because it's really difficult for every individual from across a country of millions of women who are possibly going through the same issue to come up to the Supreme Court or have access to us. Also, these cases, our organization does these cases pro bono, but more often, individuals lawyers who practice in Supreme Court do not come that cheap, which is why a lot of people do not actually even think of going to the Supreme Court. And it's difficult for people to have access to just one individual or one organization who would do it pro bono. And we are also doing we've created a lot of pressure to the government to bring in that change in law, which says that increase the 20-week limit to 24 weeks and create an absolute exception that would give the right, not just an opportunity to request, but a right to a woman to ask for abortion in case of a fatal fetal abnormality. And I think apart from that, we're also working on the procedural parts because at one point we realized that when we get abortion orders at 30 weeks and 31 weeks, it is a little difficult procedurally because unlike UK, we do not have a set medical procedure in place that could be utilized for cases of late abortion because the complications that come along with such surgeries are on a different level. So that is something that we are I think trying to work on separately, not in the court, but I think separately because that would include not just litigators and human rights advocates, but also doctors. And I think that's, for now, that's working. Yeah.
Just, if you don't mind,
yeah.
Maybe we'll just come back to that bit because I think that point
just 30 seconds.
Allies is...
Yeah, 30 seconds. Okay. So I think I'll just wrap up by saying that for now, I think India as a country, not, I think, beyond the law that we have, we're doing quite progressively, and I'm hoping that we would see a reform in law very soon. Thank you.
Want to stay here. Thank you so much. And we definitely will come back to that point at the end about how you build those allies within the medical community and the courts. And I use the word allies intentionally not to imply that there's some sort of pro-choice coup happening here, but that it is very important, particularly when you have these instances where, for example, the medical board is either incapable of making a decision or in countries where doctors may face prosecution on their own. How do you share information and spread information in a way that might build the movement without criminalizing your allies or alienating them? So thank you very much. And Lucia, would you like to?
Good morning. I want to apologize for my English. I am a feminist lawyer and work in the area of litigation and legal defense at the Center of Legal and Social Studies, CELS, one of the most prominent human rights organizations of Argentina. I am very glad to be here to exchange experience and strategic and tactic for our fight for women's rights. CELS was founded in 1979 in the midst of the last military dictatorships in order to respond to the urgent need to take quiet and decisive action to stop gross and systematic human rights violations occurring in Argentina. After the restoration of the democracy in 1983, in addition to continue to fight against impunity for crime committed during the dictatorships, CELS expanded its focus on new and emerging critical human rights issues of today's democratic context. Our principal mission is to promote and protect human rights and strengthen the democratic system in Argentina and abroad. Our specific institutional objectives include report human rights violations, influence the scene of public policy based on respect for fundamental rights, promote legal and institutional reform to improve the quality of democratic institutions, and expand the exercise of rights for most vulnerable sectors of society. In order to achieve this, CELS use several tools such as national and international strategic litigation, research and advocacy on public policy. This work is also done in partnership with other national and regional international organizations as INCLO. In the last 10 years, we also incorporate in our agenda the struggle for the sexual and reproductive rights of women and against gender violence. We consider this one of the biggest deaths of the democracy. In Argentina, since 1921, abortions are only legally accessible when pregnancy poses threats to the woman's life or health, or when pregnancy is the result of rape or violation of the integrity of mentally disabled woman. Despite the criminal code permits abortion, under this circumstance, the legal text was interpreted arbitrarily by judges and professionals of the public system of health. Recently, in 2012, the Argentine Supreme Court ruled that all women should have access to legal abortion in case of rape, and demanded that provincial authorities establish protocols that respect women's human rights regarding their personal autonomy. The court, in the case FAL, clarified the extent of the rule and incorporated human rights standards. However, there is still a strong resistance against the implementation of this rule, and women continue to be criminalized when they try to access health service, to have abortion with serious consequences for their health and life. In our country, approximately 100 women die annually from botched abortion, making unsafe abortions the leading case of the maternal mortality. The extremely high number of abortions indicate that criminalization has little or no effect on women's decision to have one. That is, it is not act like disincentive. Likewise, what we are seeking is to protect the fetus. Criminalizations have never been effective in this regard. Criminalization, on the contrary, only results in clandestine abortion, unsafe abortion, and particularly on higher mortality rates from poor and young women. Protecting life can only be achieved through robust public policies to have as it is centered women's rights, such as comprehensive health service that include pre-abortion and post-abortion counseling. For this reason, health work and sexual and reproductive rights focus on reducing the legal and institutional stigma of abortion through three lines of action. 1, advocacy for the legalization and discrimination of abortion in general. 2, promotion the access to non-punishable abortion. And 3, they demand better access to abortion medication in Argentina. We articulate our local, regional, and international work. We have investigated and generated evidence of the consequences of criminalization of the abortion in the annual report since 2009, and we have carried forward advocacy action at the regional and universal human rights bodies. In 2015, we coordinated elaboration of the SHARE report and the Human Rights Council. How we do it? First, regard our first line of action, we contribute a human rights perspective to the debate to the legalization of abortion. And in 2012, we became a member of the national campaign to the right to legal, safe, and free abortion. Second, when we have carried out various strategic litigation action for access to non-punishable abortion across the country. In 2014, with Amnesty International Argentina, and with the Latin American team on justice and gender, ELA, we sued the National Ministry of Health because it was failing to ensure access to legal abortion according to the Supreme Court ruling on the caso FAL case. In addition, with other human rights organizations, we demand the Minister of Health of Buenos Aires City to guarantee legal abortion in the city. We also submit amicus curiae in a case of a young woman who was criminalized for accessing post-abortion care in a hospital. In this amicus brief, we highlight human rights standards on the matter. Since evaluate the implementation of the National Program of Sexual Health and Procreation, includes its mandate regarding legal abortion service and post-abortion program, and present freedom of information requests to find out about the state of implementation of program in the Buenos Aires province. Regard our the line of action demand better access to abortion medication in Argentina. We have been working toward making abortion medication more accessible. Despite the costs under which legal abortion can be performed performed according to the Supreme Court and the Criminal Code. And despite the Minister of Health's recommendation for medical abortion, no abortion medication has been officially recognized by the Argentine Health Authority. The World Health Organization recommends two medicines for safe abortion, misoprostol and mifepristona, which they consider essential medicines. The production and commercialization of the main medication, mifepristona, is not authorized in Argentina. Misoprostol has only been approved by the National Administration of Medication, Food Products and Medical Technology, and MAT, in combination with diclofenac sodium, exclusive for gastric purposes. In obstetric use have not been recognized, as its sale methods are extremely restrictive, making it highly inaccessible for women. Moreover, the pharmaceutical company, Laboratorios Beta, abused its monopoly over the production and commercialization of misoprostol, imposed exorbitant price. Since misoprostol is not recognized by the government as an essential medicine for women's sexual and reproductive health, it is not included in the obligatory medical plan that healthcare providers must comply with. For this, in 2015, in collaboration with lesbian and feminists and other organizations, we filed a complaint before the Commission of the Defense of the Competition against Laboratorios Beta for abuse their dominant position in the misoprostol market. Since the Secretary of Commerce has yet to resolve our request for sanction and preventive measures, the company continued their abuse practice at the expense of women's health, perpetuating economical barriers. Last year, we also filed a formal request before ANMAT to obtain a new resolution that regulates misoprostol sales conditions. This formal request aims to have restrictive regulation removed and have the obstetric use of misoprostol recognized in the packaged leaflet. We don't expect to have a favorable answer, so we are preparing to begin a judicial process on this case. Furthermore, in 2014, we present a shadow report to the Committee of Economic, Social and Cultural Rights that include a specific section on inequality and barrier to accessing misoprostol. Recently, we have started a research to investigate practice of forced sterilization, forced abortion, and forced contraception in flight of women with disability in a mental hospital, Melchor Romero, in the Buenos Aires province. We will generate evidence about the special vulnerable group of women and show how the public health system operates in detrimental way in their life. Yes.
You might just, when you're ready to finish that point, so we can carry on to Seham, and then we'll
Okay. Well, this is the sales agenda for abortion rights. Actually, we are in a difficult situation in front of a government with a strong setback in the matter of human rights. In addition, there have been changes in the Supreme Court. But the women movement under the slogan "Ni una menos, not one less," is a very strong, active, and on the streets. We need to be creative and articulate strategies at regional and international level to legalize the abortion. Today, we hope to know your experience and share a strategy for this objective. To sum up, I would like to finish. I would like to share with you our public demand of the national campaign for the right to legal, safe and free abortion. Sexual education to decide, contraceptive no to abort, and legal abortion not today. Thanks.
I think one of the most important points that you raised right at the end there is the strength of the movement on the streets. That's certainly something that anyone who's opened their eyes in Dublin over the past few years would have seen. And it's also something that I think will come out quite strongly when Seham is speaking, and also that intersection that's come up twice now of abortion rights and the rights of young girls. And in various countries, those rights are carved out in different ways, but I think that is something that is quite important, and particularly as Seham starts to speak about these concepts outside of an urban center, particularly when, as we were talking a bit about yesterday, the intersection of this and child marriage. And so I think that's something that also will come through a bit right now.
مساء الخير. أنا اسمي سهام عثمان من مصر، وبشتغل في منظمة في أسوان، في محافظة أسوان، اسمها جنوبية حرة. احنا بنشتغل على حقوق النساء، احنا نعتبر منظمة نسوية. أهم النقاط اللي بنشتغل عليها هي مناهضة العنف في محافظتنا وفي الجنوب عامة يعني، وإنهاء جميع أشكال التمييز ضد المرأة، وكمان الصحة الإنجابية والجسدية للنساء.
My name is Seham Osman. I'm from Aswan, and I work as an activist in the feminist organization Ganobiya Hurra. And one of our main focuses is on the rights of women, particularly the reproductive rights of women, as well as advocacy against discrimination of Nubian marginalized communities in Egypt.
بالنسبة للإجهاض في مصر أو في المنطقة العربية كلها، هو إحنا عندنا 3 نقاط مهمة بنتكلم فيهم. إن القانون المصري نفسه بيجرم الإجهاض، مش بيتيح الإجهاض غير في حالتين، والحالتين يعني هو بيسميهم دول حالات الخطورة القصوى، اللي هي لو الطفل اوريدي توفى داخل رحم الأم، ولو الطفل مشوه والأم والأب قرروا إن هم يستغنوا عنه.
So in Egypt in particular, and in Arab countries in general, there is criminalization of abortion. In the case of Egypt, there are only 2 cases in which abortion is permitted by law. And the first is if the child, the fetus, is actually already dead. And the other case is if there is a severe disability that is found among the child and the fetus.
الفكرة إن حتى القانون نفسه اللي هو ده ما يعتبرش قانون يبيح الإجهاض، هو بيجرم الإجهاض. بس حتى في الحالة دي لو الأم والأب قرروا إن هم يعملوا الإجهاض ده وتوجهوا المستشفى علشان يعملوه بطريقة آمنة، ممكن يتواجهوا برفض من الدكتور نفسه، لأن الدكاترة عندنا ممكن ياخدوا القرارات مش على أساس القانون، ممكن على أساس الأهواء الشخصية أو الوازع الديني. هو شايف إن الدين الإسلامي ممكن يكون بيحرم الإجهاض من وجهة نظره هو، من غير ما يقرأ تفسيرات أو يشوف الدين الإسلامي بالفعل بيقول إيه. بس هو ممكن يمنع عملية إجهاض في المستشفى، وتضطر الأم أو الأب يتوجهوا لأماكن غير آمنة بتعرض صحة الأم للخطورة، علشان هو الدكتور قرر إن هو ما يعملش العملية.
So in some cases, even when the parents do choose that the fetus to terminate the pregnancy as a result of the fetus having severe disabilities, the doctor has to permit for this. And there are some cases in which the doctor refuses to give this recommendation as a result of his own religious beliefs.
خاصة كمان إن الوضع معقد في مصر علشان القانون بيحرم الإجهاض عامة، ففي صعوبة بتواجه الفتاة لو بتمارس حياتها الجنسية خارج إطار الزواج، فدي مستحيل هتقدر تحصل على إجهاض آمن داخل المستشفيات. وكمان الفتاة اللي بتتعرض لاغتصاب في الشارع أو اغتصاب من أحد من العائلة، القانون ما بيبيحش ان هي تقدر تعمل اجهاض للطفل ان نتيجة الاغتصاب.
So the law does not protect the rights of individuals within the society who choose to practice their sexual rights, and particularly in cases of women who choose to be sexually active within Egypt, it is difficult for them to have an abortion, the right to safe abortion, which results in these women having to go to unsafe abortion clinics.
أو في بعض الحالات يعني من القصص اللي بنسمعها من بعض الفتيات إن ممكن تروح لطبيب، تتوجه لطبيب ويبتدي يقول لها تاخد أدوية علشان الطفل يموت داخل الرحم الأول، بعد كده يقدر يعمل لها عملية الإجهاض، فهو كده بيعرضها لخطورة أكبر في الحالات دي. فأكتر من حالة البنت تعرضت لنزيف وموت يعني داخل لما سمعت كلام الدكاترة دول يعني.
There are even some cases in which women and girls would approach a doctor seeking terminating the pregnancy, and the doctor actually requests that these women and girls take pills in order to cause a miscarriage, at which point he or she would then be able to have an abortion.
وسريعا في نقطة مهمة، احنا لو بصينا للوضع الصحي للأطفال في مصر هو وضع غير صحي تماما. الدولة مش بتوفر أدوية لمنع الحمل، مش بتقدر يعني تضمن حقوق طبيعية للطفل ده بعد ما يتولد. فحتى لو في الظروف الطبيعية في وجود أم وأب مقررين إن هم مثلا مش هيقدروا يتحملوا مصاريف طفل آخر، ورغم إن هم بياخدوا مش قادرين يلاقوا أدوية منع الحمل، فده كمان مش بيتوفر لهم. فده مش مفهوم ليه القانون بيجرم الإجهاض رغم عدم توفير الدولة لكتير من التزاماتها زي أدوية منع الحمل أو الرعاية الصحية للطفل بعد الولادة.
In the absence of government provision of contraception, even in the form of contraceptive pills, and in the lack of social services by government, it does not make sense that the government continues to criminalize abortion.
وخاصة كمان إن لو الطفل نتيجة علاقة جنسية بره الزواج، المحاكم في مصر ما بتقدرش تثبت نسب الطفل ده، وما بتنظمش قوانين النسب الطفل للأم دي عشان تقدر بعد كده يتعيشوا يعني حياة طبيعية في مصر.
And for children who are born out of marriage, the government and the courts do not have a system of recognizing this child, and so the social provisions are ineffective for such cases of children.
احنا آخر نقطة هتكلم فيها إن احنا دايما يعني في ما بين المؤسسات حوار عن موضوع الإجهاض الآمن. أكتر نقطة بنقف عندها هي الحوار الأخلاقي ما بين المفاضلة، إزاي هننهي حياة طفل. بس احنا دايما بنقول ان طول ما هو لسه جنين بيتكون هو كده ما اصبحش بني ادم، احنا بننهي حياته. لكن إن من حق الام ان هي تحافظ اولا على سلامة جسدها، وكمان يبقى لها الاختيار او في وقرارها الخاص بالاحتفاظ بالطفل ده من عدمه.
And the last thing that I would like to discuss is the fact that there is a right of women to seek their to have reproductive rights, and to make these types of decisions regardless of what society may think.
شكرا.
Thank you.
Thank you very much, Seham. Having had the opportunity to visit Seham in Egypt and conduct some research with her last year, I think one of the most stunning things about her work is the ability to continue despite the displacement. The sort of physicality of the space in which she is working involves communities who have been up and moved from the Nile, where they knew how to live and to keep each other alive, and are now living in a space where traditional forms of medical care have been degraded, and traditional family structures and housing structures have been degraded, and that has further kind of eroded women's access to a reproductive justice that actually looked a bit more just 60 years ago than it does today because of the way that they can access things. So I clearly have about 100 questions of my own, but I'm conscious of time, so I was wondering if we could maybe open it up to questions now. Great. Yep, over there.
Hello, my name is William Quill, and it's very good to hear the perspectives from around the world. One of the things that was touched on a few times is where there are, as I suppose, exceptions for cases of rape. And it's one of the things that are being considered at the moment here in Ireland. And it's something that I don't think is being, it got a lot of scrutiny at the committee, but in public discourse, about what that would actually mean for somebody who, within a very short space of time of a sexual crime, of having to report this in a particular way. So I'm curious as to the experience of how this is actually implemented and the reality of how this wouldn't be efficient, a good means for protecting women's rights.
Okay, maybe we'll take two more and then allow them to answer, if there are any more. Okay then. Lucia, would you like to start on the question about the exception to rape?
En realidad, el sistema de causales, como el que hay en Argentina, es muy limitado. Digo, pensar en, digo, como nosotros tenemos regulado en el código, pensar que solo en esas hipótesis la mujer podría llegar a decidir hacerse un aborto, es complicado. Digo, las limitaciones del sistema de causales es lo que se ve hoy en nuestro país con relación a la cantidad de muertes y sobre todo con relación a la criminalización de las mujeres que acceden a los servicios de salud frente a una emergencia obstétrica. No, digo, lo que sucede en nuestro país muestra lo limitado que es el sistema de causales para pensar la regulación del aborto.
So the issue of just limited instances in which abortion is allowed is something that we already have in Argentina. We already have the possibility for women to access abortion in case of rape. However, we see the limitations of this because women are still criminalized when they get to a hospital, when they reach a health center. So we really in Argentina is really an example of the fact that this approach is very limited. This approach of limiting abortion to just a certain instances, certain reasons.
Rape, there is a specific set of procedures that are followed, wherein once a crime is reported, automatically it is not upon the woman to go to the court and ask for an abortion. In a normal case, that would fall within 20 weeks. The police would go to the district court. They do not really have to go to the High Court or the Apex Court for an order. They would have to go to the district court, which is the basic level of court in India, to go and seek for an abortion, because that is something that has been mandated under the law. The problem that we face is where a case is reported really late, which is very often the case of minor rape victims like the one I mentioned. That is something that we are still struggling with, and only individual cases have come up. And apart from that, there are cases where I think it is not initially detected, and then women fail to go and get follow-up checkups from the doctor, which then come up in the post-20-week cases. So then again, even with the post-20-week cases, we're still trying to argue those cases on the basis of the effect of such a pregnancy on the mother because it's cause of rape. And apart from that, yes, like separately, we are trying to argue and bring upon a more solid guidelines on such exceptions. But generally, in cases of assault and rape, for women up till 20 weeks, it is not upon her, but automatically the police and the hospital would get an order for her. And ideally, it would be a smooth process.
Unfortunately, due to the time, we are going to have to end our conversation here, but each of our wonderful panelists have offered to continue the conversation with you separately, and I believe that they will all be around with their translators for the rest of the day. So thank you very much, and just a final round of applause for our